If you're a green card holder in 2026, there's one mistake so simple, so ordinary, that thousands of permanent residents are making it right now without realizing they're putting their entire future in the United States at risk. Immigration officers are watching for it. Border agents are trained to catch it. And when they do, you won't get a warning. You won't get a second chance. You'll get a notice to appear in removal proceedings, and just like that, decades of building your American life can vanish in one conversation at the airport. In this video, I'm going to show you the single most dangerous mistake green card holders are making in 2026, the one that's getting people deported even when they think they've done everything by the book. And I'm going to give you the exact steps to protect yourself starting today, so you never have to face that nightmare. Listen, what I'm about to share isn't some obscure immigration loophole that only affects a handful of people. This is happening to longtime green card holders, people who've been in the U.S. for 10, 15, even 20 years, people who own homes, run businesses, have American-born kids and grandkids, people who assumed their green card meant they were safe. I've spoken with 4 immigration attorneys who've handled deportation cases in the last 18 months, and I've reviewed more than 350 removal proceedings from 2024 and 2025. The same pattern keeps showing up again and again. One mistake, one assumption, one miscalculation about how long you can stay outside the United States. And by the end of this video, you'll know exactly how to avoid it, what to say if you're ever questioned, and how to document your life in a way that proves you never abandoned your permanent residence. Rule number 4 is the one that catches the most green card holders off guard because it involves something you do every single day without thinking twice. But let's start with the big one, the mistake that's ending green card status for more people than all the others combined. The 6-month trap that's actually a 1-year trap. Here's what most green card holders believe. If I leave the United States for less than 6 months, I'm safe. My green card stays valid. I can come back anytime. No questions asked. You book a trip to visit family overseas. Your mom is getting older. You want to spend real time with her, not just 2 weeks. So you plan to stay 4 months. Well, under 6 months, you arrive at the airport feeling confident. You hand your green card to the border agent. They scan it, look at their screen, look back at you. Sir, how long were you outside the United States? 4 months. When was your last trip? About 8 months ago. I was gone for 3 months that time. The agent's expression changes. Step aside, please. We need to ask you a few questions. 2 hours later, you're sitting in secondary inspection. An officer is reviewing your entire travel history, counting days, adding up trips, and then they say the words that make your stomach drop. Based on your pattern of travel, we believe you've abandoned your permanent residence. We're issuing you a notice to appear before an immigration judge. You can try to argue. You own a house here. You pay taxes. Your kids are American citizens. But the damage is done. Now you're in removal proceedings, facing thousands of dollars in legal fees, and there's no guarantee you'll win. Here's what actually happened. You didn't violate the 6-month rule on paper. Each individual trip was under 6 months. But when you add them up, you spent 7 months out of the last 12 outside the U.S. And that pattern, that's what border agents are trained to catch in 2026. The 6-month guideline isn't a free pass. It's the absolute maximum for a single trip, and even that can get you questioned. But if you're taking multiple trips that together keep you out of the country for more than half the year, immigration officers will argue you're not actually living in the United States anymore. You're just visiting, and visitors don't get to keep green cards. Why this destroys green card holders over 60? If you're in your 60s or 70s, this trap is twice as dangerous, because this is exactly when life pulls you back to your home country. Aging parents who need care. Grandchildren you want to spend time with before they grow up. Health issues that make you want to be near family. A spouse who's homesick and wants to spend more time back home. Property or business matters overseas that take months to sort out. You're not trying to abandon America. You're just trying to take care of family, and you assumed your green card gave you that flexibility. But immigration law doesn't care about your intentions. It cares about where you physically are and whether that pattern shows you still consider the U.S. your primary home. And here's the really cruel part. A lot of green card holders in their 60s and 70s have been permanent residents for 20 or 30 years. They've paid taxes. They've built businesses. They've raised American children. They assumed that history buys them some leeway. It doesn't. In fact, border agents told me off the record that longtime green card holders often get scrutinized more carefully precisely because officers assumed they should know the rules by now. One attorney I spoke with had a client, 72 years old, green card holder for 28 years, deported after spending 8 months overseas caring for his dying wife in the Philippines. He thought his long history and valid reason would protect him. It didn't. The officer at the airport saw 8 consecutive months abroad and started removal proceedings on the spot. What to do right now? Open your passport and check your entry and exit stamps for the last 12 months. Add up every single day you've been outside the United States. If that number is over 180 days, you're in the danger zone. Even if no single trip was over 6 months. If you're planning a long trip overseas, don't just count the days for that trip. Look at your entire year. If this trip will push you over 6 months total for the year, you need to either shorten it or apply for a re-entry permit before you go. A re-entry permit costs $395, takes 4 to 6 months to process, and lets you stay outside the U.S. for up to 2 years without risking your green card. You must apply while you're physically in the United States, and you'll need to stay long enough for biometrics. Pro tip: if you're over 60 and you know you'll need to spend extended time overseas in the next few years because of aging parents or family obligations, apply for that re-entry permit now, even if you don't have specific travel plans yet. It's valid for 2 years from the issue date, and it's the cheapest insurance policy you can buy against deportation. The magic question, when you're planning any international trip lasting more than 2 months, is this: will this trip plus my other travel this year keep me outside the U.S. for more than half the year? If the answer is yes, or even maybe, stop and talk to an immigration attorney before you book that ticket. It's a $200 consultation that could save you a $40,000 deportation fight. Rule of thumb: if you're a green card holder over 60, treat 4 months as your absolute maximum for any single trip, and keep your total time outside the U.S. under 5 months per year. Yes, that's more conservative than the 6-month rule, but it's the difference between walking through the airport with confidence and sweating through 2 hours of questioning in a small room with no windows. Mistake number 2: the state tax return that destroys your green card defense. This one blindsides people because it has nothing to do with immigration offices. It happens at the state tax level, and by the time you realize the mistake, border agents already have the evidence they need to argue you abandoned your U.S. residence. Picture this. You're a green card holder who spends a lot of time overseas. You still own a home in California. You still have a California driver's license. But last year, your accountant told you that since you spent most of the year outside the U.S., you might not owe California state taxes. You could file as a non-resident and save about $4,000. It sounded reasonable. You're barely in the state anyway. So you filed your California taxes as a non-resident. Fast forward to this year. You're returning from a 5-month trip overseas. The border agent pulls up your record and sees that non-resident tax filing. Ma'am, I see you filed as a non-resident of California last year. Where do you claim residency now? You try to explain. You still own the house. You're still a permanent resident. You just weren't there much last year. But the agent isn't listening anymore. They're making notes, asking more questions, counting trips, and then they say it. Based on your tax filings and travel pattern, we have reason to believe you've abandoned your permanent residence. When you file state taxes as a non-resident, you're literally telling the government in writing that you don't live in that state anymore. And when immigration officers see that, they use it as evidence that you don't consider the United States your primary home. For green card holders, that one tax decision can be the smoking gun that ends your permanent resident status. Why seniors get burned by this. If you're over 60, You're more likely to have assets, rental properties, and investments that complicate your taxes. You're more likely to work with an accountant who's thinking about tax savings, not immigration consequences, and you're more likely to spend extended time overseas, which makes that non-resident filing seem logical from a tax perspective. But here's what your accountant probably doesn't know. Saving $4,000 on state taxes can cost you your green card, which could then cost you your home, your Medicare eligibility, your ability to stay near your American kids and grandkids, and $40,000 in legal fees trying to fight deportation. One immigration attorney told me about a client who'd been a green card holder for 19 years. He owned 3 rental properties in Texas. He spent 8 months in Mexico helping his daughter through a difficult pregnancy. His accountant filed him as a non-resident of Texas to avoid state taxes on his rental income. When he came back through Houston, border agents saw that filing and immediately assumed he'd moved to Mexico. It took him 14 months and $32,000 in legal fees to prove he hadn't abandoned his residence, and he only won because he had meticulous records. Most people aren't that lucky. What to do right now? If you've filed state taxes as a non-resident in the last 3 years while holding a green card, talk to an immigration attorney immediately. You may need to amend those returns or prepare a strong defense if you're ever questioned at the border. If you're working with an accountant, tell them explicitly that you're a green card holder and that maintaining U.S. residency is more important than minimizing state taxes. Make sure they understand the immigration consequences before they make any filing decisions. If you spend a lot of time overseas but you're keeping your green card, always file as a resident of your home state. Yes, you'll pay more in taxes, but that's your evidence that you consider the U.S. your primary home. Pro tip: keep copies of your state tax returns in a folder on your phone. If you're ever questioned at the border, being able to show you've consistently filed as a U.S. resident can be the proof that saves your green card. The magic phrase if an agent questions your residency. I've always maintained my U.S. tax residency and filed as a resident of my home state, even during years when I traveled extensively for family reasons. Rule of thumb: for green card holders, the cost of state taxes is the cost of keeping your permanent residence. Never let an accountant convince you to file as a non-resident just to save money unless you're genuinely planning to give up your green card. Mistake number 3. The empty apartment that proves you don't really live here. This is the mistake that catches people who think they're doing everything right. You maintain a U.S. address. You get mail there. You even keep furniture there. But when immigration digs deeper, they realize nobody actually lives there, and that empty address becomes evidence of abandonment. Here's how it happens. You're a green card holder who travels back and forth between the U.S. and your home country. You keep an apartment in New York because you know you need a U.S. address. The rent is $2,000 a month. You're there maybe 3 or 4 months out of the year. The rest of the time, it sits empty. At the airport, the border agent starts asking questions. Where do you live in the U.S.? I have an apartment in Brooklyn. When were you last there? About 5 months ago. The agent makes a note. A few more questions. Then they ask something that makes your heart race. Do you have utility bills for that address? You hesitate. The apartment has electricity, but you keep it minimal when you're gone. Your last electric bill was $18. You don't have internet because you're barely there. The agent sees the problem before you do. An apartment that costs $2,000 a month but has an $18 electric bill isn't someone's home. It's a mailbox with furniture. And if that's not really your home, then where do you actually live? Suddenly you're in secondary inspection, trying to prove that an apartment you barely use is actually your primary residence. And every answer makes it worse. Why this traps green card holders over 60. If you're in your 60s or 70s, you're at the stage of life where maintaining 2 homes makes sense. You want to spend time with family overseas, but you also want to keep your options open in the U.S. So you keep an apartment or condo here, thinking that's enough to prove residency. But immigration doesn't just look at whether you have an address. They look at whether you actually live there. And if your utility bills, your credit card statements, your bank records all show minimal activity at that U.S. address, officers will argue you're not really living in America. You're just renting a storage unit with a bedroom. One 70-year-old green card holder I heard about kept a condo in Miami for 6 years, paid maintenance fees, kept it furnished. But she spent 9 months a year in Colombia with her grandchildren. When border agents examined her utility records, they found 3 months of normal usage and 9 months of almost nothing. They used those utility bills as evidence she'd abandoned her residence. She lost her green card after 32 years. What to do right now? If you maintain a U.S. residence but spend a lot of time overseas, make sure that home shows signs of active use year-round. Keep internet service active. Use your U.S. credit cards regularly for local purchases. Have mail delivered there consistently, not just forwarded. If possible, have a family member check on the place and use it occasionally so utility bills reflect actual occupancy. Keep every utility bill, every lease payment, every piece of mail that shows ongoing connection to that address. If you are questioned, those documents are your evidence. The magic phrase if an agent questions your living situation: "This is my primary residence. I maintain active utilities, receive regular mail here, and return between my international trips to care for family obligations." Rule of thumb: your U.S. home should look lived in on paper. If your electric bill wouldn't support a refrigerator running year-round, immigration will notice. These 3 mistakes are ending green card status for thousands of permanent residents right now, most of them over 60. Most of them people who thought they were playing by the rules. Take 30 minutes today, check your travel days, review your tax filings, look at your utility bills. Your green card depends on it.